Good morning, everybody. Excuse me. Starting off well. Let's try that again. Good morning, everybody. Welcome to the Courtroom Files Live. We're going to start our day with Judge Simpson.
For preliminary examination, people are able to proceed this morning. I would anticipate a motion to dismiss the felony. I would be seeking a remand on misdemeanor, but I seek the court's guidance as well. It's charged as a DD first, and it should be a DD second. I apologize to the court of counsel that I do not have a amended complaint prepared, but I could move to add a count 3 of DD second or amend count 2, whatever the court's preference is.
Oh. Can we, Ms. Zenda is like an expert at getting those amended complaints done. And so I think Ms. Zenda might help you out there.
I think she's doing the things right now.
Oh, is she? Okay, see? So what I will do then is, and should we do that? I mean, it's my case, so I'll remember, but should we do that as count 3 or just amending count 2?
Just amending
Count 2, you think will work? Okay. So we'll just amend count 2 to reflect into DB second.
Wonderful. Thank you.
And you're waiving reading on that?
Yes, sir.
And I'll just indicate that we'll maintain his plea to the amended count 2 in this matter of DB second. Count 1 would be dismissed as people are unable to proceed. I'll set a pretrial in this matter for
May 19th at 1 p.m.
May 19th, 2025, 1 p.m. That's before me.
Thank you, Adam. May we address the issue of bond?
Sure.
My client was out. He had difficulty, and I believe there were issues with
positive drops.
With positive testing.
Get back to work.
My client does have employment. He is hoping that the job is maintained for him, but he does not think it will be maintained for too much longer past today's date. The felony charge was dismissed because there is no complaining witness. I expect there will probably not be a complaining witness at the court date as well. Based on that, Your Honor, I'd ask that my client's bond be returned to its previous state. My client has indicated that he will follow all of the strictures of the court. He has learned the importance of not indulging in drug use during any time period. He's asking that he be allowed to have his bond reinstated. The time he has sat in has taught him a valuable lesson.
The problem is that he was testing positive. That's part of the problem. The other part of the problem is he was supposed to then start CCOP and he didn't appear.
I talked to the agent and working a lot of hours. Told me to come to court and signed up for the COP or whatever, because I can do intensive outpatient treatment.
So, Your Honor, he did have contact, but the problem was at the time he was working a lot of hours, and he had gone past the time when he should have been reporting. He did speak to the agent. Agent told him to come to court, and then he could start getting into the program then. It's not that he doesn't want to. It's not that he intentionally tried to avoid what needs to be done. He set priorities with working and maintaining himself and his family. And that priority, as it turns out, was the incorrect. He has learned then what the priority should be. And again, it's not like he didn't make contact at all. He did do that. He was working. He'd like to continue to maintain that employment.
Okay, I don't need a response from people. I'm going to, at this moment, deny your request. I'll look at it again come the 19th, since it's coming back before me. It's just less than 6 days from now. I'll take a look at it. I would like to see something that's going to keep him on track, because if he continues to use, doesn't do anything, we're gonna be right back in the same boat. So
I'm not going to use, my job is at risk and I'm for positive drops and I can guarantee that, I'm just trying to get back to work. My job is,
no, I hear you.
yeah, just Simpson,
But-
I really learned my lesson. Like, I understand like the importance of not dropping dirty and things like that. And I have learned my lesson. I don't need to be in here. If you give me a chance, I won't let you down. I really just trying to get back to work. And
How many times do you think I hear that?
a lot, Your Honor, a lot. And I
So
guarantee,
tell me what makes you different.
because I got 6 kids, I got a lot of things going on, and I'm not a person that constantly gets in trouble. I'm done with the drug use. My system is clean, so you have no problems with that. So if I drop today, drop next week before I come to court, everything could come back the same. And you got my word on that. Like,
So if I were to let you out, if I change my mind and I were to let you out, you test dirty or don't follow anything.
I would do the time in jail. But I'm
You're
not.
gonna do it right now anyway.
Yeah, but I'm not trying to do that. But what I'm saying is, I come back and plead guilty to everything. I'm just really trying to get back to work, and you won't have no problems out of me
I
after
think you
today.
need to get yourself set up with some type of outpatient treatment.
Yeah, and that's what I'm saying. If I go to community corrections today, I can sign up for the intensive outpatient treatment, so I can be able to get on the right track. But there will
I'll tell you what, I'm gonna at this moment deny your request. However, if council would contact community corrections, see what they need, I will consider an order to release him with some strict compliance in their program.
See if they have something in place for you.
Okay.
Oh, yeah.
Please.
So I'm not saying no forever, but I'm gonna need something that,
Thank you, Your Honor.
thank you.
So,
Thank you, Judge.
And after that,
You have to turn off center stage. Huh?
Sorry.
Just walk in, start throwing things down? What? I'm not, no, too easy. Not gonna say anything. Welcome back. All right. So what are we doing? This one? Got him? Okay. Court calls the case, People versus Timothy Stevens.
Alexander, on behalf of the people, Your Honor.
Oh, you're back.
Student Attorney Kara Rosengren, on behalf of Mr. Stevens, Your Honor. Say your name.
She's back.
Stevens.
Your name, sir?
Timothy Stevens.
Thank you.
In Your Honor, today's concept of preliminary examination, at this time, the people are unable to proceed as to counts 1 and 2, ask that count 3 be remanded to district court.
So you're moving to dismiss counts 1 and 2?
Yes, Your Honor.
Counts 1 and 2 are dismissed. I'll maintain the defendant's not guilty plea as to count 3. Set a pretrial in this matter for
June 5th, before Judge Fresh Hour.
June 10th, you said? 5th, 2025, 10 a.m. I'm sorry. 10 a.m. before Judge Fresh Hour. Well,
Thank you.
yeah, continue.
Thank you, Your Honor.
Thank you. She's a lot nicer than you, Apple. I just thought I'd throw that out there. She didn't give me a lot of argument about stuff. Isn't that true? No? Why, man? It's supposed to. Me and you. No, she's really not.
Oh, whatever.
She's okay. That's it? That's all we have ready? What are all these people doing here now?
Came to see you.
Is that what you just said? Okay. Well, I guess I'll take a break and wait for more to get ready and then come back. She's leaving? Does she have to go with Apple? I like her better.
Better?
Okay, better may be the inappropriate word. To dismissal, okay. Do this. Court does call the case, People versus Deborah Gilmore.
Katie Rosmersky for the people.
Yes, Your Honor. Brandon Bird on behalf of Deborah Gilmore. Ms. Gilmore, can you please state your full name for the record?
Deborah Gilmore.
Morning, Your Honor. People are unable to proceed at this point.
Respectfully request dismissal, Your Honor.
I request a remand for this meeting.
All right. People being unable to proceed as to count one, that is dismissed. I'll maintain the not guilty plea as to count two. I'll set that for a pretrial on
June 9th at 9 a.m. before the Washington.
June 9th, 2025, 9 a.m.
Yes.
9 a.m. before Judge Wash.
Thank you, Judge.
Thank you, Bond.
Right.
Go continue. Thank you. Take care. That's it. Okay, then I'll stand in recess and you'll let me know when we're ready on other things. So court's in recess. All right.
Yeah.
Alrighty, good morning again, everybody. Welcome to the Courtroom Files Live. Happy Tuesday. I hope you're all having a great day. Interesting thing happened last night after we did the video with the Harris County Criminal Lawyers Association and showing that. All sorts of other court channels suddenly figured out that was a thing and started showing it. How weird. It's good to be a trendsetter, I guess. Let's go over to Judge Simpson, or Middleton, rather, and say good morning to him.
The amended complaint, which the prosecutor's office filed yesterday, changes the charge to use of cocaine or possession of cocaine, which is a felony punishable by up to 4 years imprisonment, as a second offense, making it an 8-year maximum offense as a third habitual. So it would reduce the maximum to 15 rather than life. But use of a controlled substance, whether it's heroin, prescription drugs, cocaine, fentanyl, or meth, all of those are misdemeanors punishable by up to a year in jail and a fine of up to $1,000. Do you understand the charge, Mr. Baker? Plead to a 1-year misdemeanor of use of a controlled substance.
Yes, Your Honor.
Mr. Robert has confirmed the plea offer. You agree, Mr. Nossinger?
Yes, Your Honor.
All right. Now, you were here when I went through the advice of rights just a few minutes ago live, and then your lawyer had you sign this one. So you understand you're giving up your rights to have a trial in front of a judge or jury.
Correct.
All right. So let's talk about this. You got pulled over right here in Centerville on March 24th on a traffic stop. Had a shotgun shell container, some keys, and in a hidden storage space inside the shotgun shell, some controlled substance was found. And it was tested and it turned out to be cocaine. Did you have some cocaine in your possession at that time?
Evidently, yes, Your Honor.
Had you used some of it?
No,
How did you come to have it?
I collect keychains and I got
You
the
collect-
keychain Yeah, I collect keychains.
Okay,
And I got the keychain about 2.5 years ago from a friend of mine. Never knew it opened up. So, I mean, had no reason to open it up. I was just as shocked when he was when he opened it up, it fell out.
all right, well, let's talk about that. You can plead to this charge if you wish to. But it sounds to me like you've got a defense of, I didn't know it was there. And if so, that might be a defense to the charge. Do you understand?
Kinda, yes.
All right, well, let me ask you this. Did anybody threaten you to get you to plead to this charge
No, Your Honor.
or promise you anything?
No, Your Honor.
Um, do we have a picture of this thing?
It was about this big and it looked like maybe a 357 shell, but just kind of screwed together, kind of like, I guess, a shotgun shell. But I didn't even know it opened up.
Okay. Well, apparently Deputy Miller took it apart. All right, if I gave you a test today, would anything show up in your system?
Just marijuana, because I do use that for pain control in my neck.
Well, it's lawful for adults.
Anything else, I'll test negative.
I haven't seen you in a little while, Mr. Baker. What are you up to these days? Are you working someplace? You're getting
No,
disability?
I'm on disability. I try to do some lawn care once in a while. That's all I do. I take care of my grandkids.
Well, I just live down the street.
Right.
Um,
I've been doing fairly well. I mean, this is kind of a catch on me.
well, after you got this and I talked to you, you paid all your other tickets.
Yes, Your Honor.
So that's a plus. Yeah, you had couple things. You got,
We got a $350 fine that I gotta take care of.
yeah. All right, so that day, they didn't arrest you. The warrant got served on April 30th. Pled not guilty, posted bond on May 1st. So it looks like you spent 2 days in jail. Mr. O'Bear, anything else you want me to know?
Is the court accepting his plea?
I'm not sure yet. We'll continue here in a minute. Mr. Nossinger, is there anything you want me to know?
Yes, Judge, I've talked with Mr. Baker and he very much wants to take advantage of the plea agreement, but I can understand that.
Well, then we're going to discuss perhaps doing this plea by no contest. By pleading no contest, you don't admit what happened, but you also don't deny what happened. And you will allow the conviction to enter on this misdemeanor charge as a opportunity to accept the plea offer. Do you understand?
Yes, Your Honor.
Are you willing to plead no contest to this
I am.
charge? Because I'm not sure I had a factual basis. I do from the affidavit and the laboratory report. 2 days, credit 2 days. I find your story to be plausible. I haven't seen much cocaine lately. You don't have a history of cocaine use. You have some other struggles, but you want the benefit of the misdemeanor plea offer and you just got it. Fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee. That's $275. I'm going to do it as a part of a payment plan with your other case, which is 25431OT. I don't need a probation. I don't need more jail time. If there is a problem, we'll see you again soon enough.
You won't see me again.
All right, I might see you again for driving unless
No,
you stop doing that.
Hopefully.
Hopefully is right.
I'm taking some words of wisdom from you. Moving into an electric bicycle.
Yeah, stop driving a car. Yes, an e-bike would be right up your alley. You could get all over town without violating
Violate those laws.
any law. I think. All right, the bailiff's gonna take you out and set up a payment plan,
All right,
and then good luck, sir.
thank you.
Jody Lynette Wood.
We'll stick with Judge Middleton here for this next case, but he mentioned that he wasn't seeing a lot of cocaine. If you watch other courts around the country, you see just the opposite. There's judges all over that are talking about how cocaine is making a comeback. But Middleton is in a very small rural area that doesn't have a lot of money, so that might be a factor as to what they're seeing there. Anyways, just thought I'd share.
Oh, that's the only one aside from bandit.
All right, then we'll just deal with Ross in the meantime. All right, let's take a look at how Miss Wood's been in jail.
I think, yeah, she's got credit.
She also goes by Klein, so she's been in jail 11 days. Do you have anybody else back there?
Not that you need to see, Judge.
All right, thank you. Not that you got homeless people stashed back there. She's got more than that, January 13th. Good morning.
Morning, sir.
Do you prefer Wood or Klein?
Wood.
All right. We have two cases this morning with Jody Lynette Wood, also known as Jody Lynette Klein. The felony case is in file 241559. And the original complaint alleges carrying concealed weapon, a dangerous stabbing weapon on or about your person. The way this is charged, that's a felony. It's punishable by up to 5 years imprisonment. And the crime allegedly occurred July 8th of 2024. I was trying to figure this out. The warrant was sworn to by the officer in August 16th of 2024. you got arrested on January 12th of 2025. And you bonded out on January 12th. So I have 1 day there. Then you didn't show up. Adjourned 1 week, you were on behavior center. Then they had a pre-exam conference. On February 18th, they didn't show up. So Judge Patterson issued a bench warrant for your arrest. Then you got arrested again on May 1st. And you've been there ever since. So you got 12 days there. So you have 13 days total jail credit on this charge of carrying a concealed weapon, a stabbing instrument. What's the plea offer, Mr. O'Bear?
Offers for the defendant to plead to use of methamphetamine and forfeiture of the box cutter and knife that she had.
In addition, the Three Rivers City Attorney, Mr. Reed, granted authority to put their case uh, 24562 disorderly person as part of the plea agreement. Also dismiss disorderly. All right, so let's break this down, Ms. Wood. The weapon charge is going to be dismissed. You're going to plead to use of methamphetamine, which is under the Public Health Code. It's a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. The disorderly person charge from Three Rivers from March of 24 is going to be dismissed. That's got a bunch of no-shows in it too. And as far as I can count, you have 12 days of jail credit. Is anything other than this charge holding you in custody? You don't have a hold from other state or county or anything?
No.
All right, let's go through a couple of other things. I don't have your advice or rights, so let me take a minute and tell you and anybody else that's going to enter a plea that by pleading guilty to this charge, you give up your right to have a trial in front of a judge or jury. Do you understand?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You'd have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury cannot hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. I say that a lot. Understand?
Yes, sir.
Now, the affidavit in this case states it right out there. Affidavit says the affiant was dispatched a report of a suspicious situation, Constantine Road. Trooper Tracy Smith and a deputy Joseph Chittister went out there the complainant, Mr. Chittister, said you showed up in his driveway. You were very upset. You're afraid of your husband. There's been a lot of turmoil out there in your neighborhood.
Yeah.
A lot of it from your husband. And they found in your possession a meth pipe, and you said you last smoked it the night before. And you also had some stabbing instrument, box knife, and knife in your bra. So that was the felony charge, not the most compelling, but do you acknowledge that you used methamphetamine before that time?
And before.
All right, that's close enough. All right, now, you had multiple occasions where you didn't show up. You were in and out of the hospital. But you were like trying to grab smoke with your hands. You then got arrested on May 1st. How did you come to get arrested on May 1st?
The cop showed up to the house because my stepdaughter's boyfriend didn't report to the parole officer, and I was there. So they.
Or they came for another purpose, ran you and arrested you.
Yeah, that's her.
Why didn't you show up?
I was in the hospital and I don't have a vehicle. So, and when my mom will come from Indiana a lot of times to take me to appointments, but it's like an hour and a half drive one way for her to get here. And other than that, I don't have any transportation.
Well, they gave you transportation in the back of a police car.
Yes, sir.
That's not a very good excuse because you were out of the hospital weeks before this May 1st date. I'm not sure what to do here. Mr. O'Barry, have any thoughts?
She clearly has a drug problem.
Yes.
I don't know if probation would be beneficial to her to help deal with that.
Mr. Gibson, you have any thoughts?
The defendant said that she's been going to Pivotal and that apparently they were the aftercare after her hospitalization. So she said she is taking steps to be proactive in that regard. And so if I would ask the court to sentence the defendant for credit for time served as far as jail, if the court believes that she needs supervision, then I would ask for a short probation term. Thank you.
We haven't been very successful with our probation. Judge Pattison tried a probation with Miss Woodbeck in 2019, which involved testing, and we couldn't get her to test, and the probation was revoked. She doesn't have enough transportation to even get to court or inclination. And then she had another couple of larceny cases in the 2020. And then that disorderly person charge where she missed multiple court dates. So I don't see a probation being successful. Now, this happened way back in July of 2024. And you were distraught and you ran to the neighbor's house. And you ended up getting arrested because you were afraid of being assaulted, which I won't argue that point. Then did you just end up back there with him?
They didn't actually arrest me that day.
They took
me to Keystone.
Okay.
And then she just told me that she couldn't tell me that there wouldn't be charges brought up later, and this is where it was brought up.
All right. We've got a civil infraction also. So are you back with your husband? Who else is there?
My stepbrother,
What's her name?
Destiny.
Oh, and who's the boyfriend that got arrested?
I don't know his last name. His name, Cody. I don't know who, I don't really know him. I don't know his last name. He's still, when my husband came and visited me last night, they, Destiny and him.
Is that your Cody?
I'm sorry, what was the last name?
Well, she didn't know it, but he's got picked up, so we'll see. Well, anyway, Miss Wood, Destiny's got issues also. In fact, I thought there was a warrant for her. No. All right, she doesn't have the wherewithal to get to court. She has at least one previous failed probation. I think more than one, but the most recent one was 2019. We have a couple of weapons, which were not very compelling. She was fleeing a domestic assault situation. I'll take her at her word. As I said, there's been a lot of turmoil at that house. She failed to appear multiple times, but she was in and out of the hospital for medical problems and mental health problems. If they had tested you on May 1st, would you have tested positive then for meth? I'm not sure I buy that. You obviously knew there was a warrant out for your arrest, and I don't know what, you were just waiting to get picked up. When did you last have any involvement with Pivotal or any treatment people?
I had an appointment on May 7th, but I was incarcerated.
When was your last meeting with them prior to that?
Probably, I think we were gone 3 months. He was gonna see me, so probably 3 months prior to that. I gotta reschedule an appointment when I get out. But I've been going to Pivotal for quite a long time, like over 14 years. I'll continue to be going there too.
You do have a couple other things that you owe us for. Not involving threats or drugs, but involving theft. And I certainly understand, Mr. O'Bear, how you came to this plea offer. That's really what the nub of the problem is. But it was last year, it was July of 2024. In between there, the 11 days she got here, she also did some days on the misdemeanor where she continually failed to appear. Same thing. All right. I'm going to order 21 days, credit 12, leaving 9 days to serve. We'll give you a little more time to get detoxed here. 0 fine, $75 crime victims' rights fee, a $50 state minimum fee, and $150 attorney fee. $275 a part of a payment plan, and also other cases. you will get some good time days built into this. So you probably have, I'm guessing, 4 or 5 more days to do, but you continually failed to appear on both cases. One got dismissed outright. I think there is an underlying methamphetamine issue, but this was a year ago. You also had a previous failed probation and a number of unpaid retail fraud fines. So you can go with a court officer. When you get out of jail, I want you to come up here and set up a payment plan to pay this stuff off. All right, you're good to go.
Thank you, sir.
Alrighty, little update for you for anybody who tried to brave that third hour yesterday with me of yesterday's live. My formal education is actually in computer science, so I'm good at troubleshooting such matters once I'm not trying to talk to you live. And it turns out that video that I was trying to play, that part of the drive it was stored on actually had a bad sector, and that's why it was freezing every time it got to that point. So that's what that was all about. But we soldiered through, and again, thank you to everybody who stuck with me as we tried to figure all that out yesterday. Let's go over to Burnett County, Wisconsin. This is Judge Mogan, and we'll say good morning to her.
All right, we're going to address the 21 SC 179 first. And that doesn't involve you, Mr. Brimacombe, but you can stay, you can be seated right there.
Thank you.
We will go on the record in the matter 21 SC 179, Michael Burton et al. Versus Carl Ulsiams et al. Formerly doing business as Keeson's Enterprises LLC, Castle Advocacy Group, Inc., Professional Services Corporation. And we also have Susan Ulsiams present as well. We're here today on the partial remand with regards to the attorney's fees on this case. We have been waiting a significant amount of time on this appeal. The matter went up to the Court of Appeals and the court was affirmed, but it was sent back to the court as it relates to the attorney's fees. The Court of Appeals did state that as to the attorney's fees and the way that the court assessed the fees was appropriate, but in the amount of the fee of the fees and the fact that this is a case that went into significant litigation and had a substantial amount of attorney's fees, that there needs to be more information provided to the court in order to go over 3 times the award of damages to the plaintiffs. Therefore, the court does need more information from the plaintiffs and from counsel in order to proceed, unless the court is to rely on the statute, Wisconsin statute 814.04 paren 2 paren A, where there would be the idea that it would only be 3 times the compensatory damages that the plaintiffs received. I'm going to first ask for arguments from both sides, and then, or if it is requested, to go into depth as to the specific factors. Mr. Anderson.
Thank you, Your Honor. I wasn't entirely sure what the hearing was going to be about today. I mean, I knew the topic, obviously, given the Court of Appeals decision, but I wasn't certain what the court would be looking for. We can go into the list of factors, although that may be broader than what we are prepared to all do here today in terms of if the court wants additional evidence or things like that. So I don't know if it's the right thing to go into that in detail. Generally speaking, though, Your Honor, in my September 27th, 2022 submission to the court, it was a lot of it is covered in that document. I'm not going to go through all of that again. But the court is well aware of this case. The fees in this case were reasonable given the time spent, and I know that's the time spent and the hourly rate that was charged. But what I think that the Court of Appeals may have missed in this one, Judge, is the fact that this was, I think, 3 hearings in front of Commissioner Krupa, a full day in front of Your Honor, motions filed by defendants that were summarily denied and dismissed. And ultimately, Your Honor, up on appeal to the Court of Appeals. Now, I will also say that the attorney's fees that have been awarded thus far in this case do not even include the attorney's fees to deal with the appeal filed by defendants. And I think that should be taken into consideration as well when considering the award of attorney's fees in this case. Your Honor, this case was, in my humble opinion, simply over litigated by defense. And what I mean by that is, again, I just sort of said it, 3 hearings in front of Commissioner Krupa, motions filed, a full day hearing. And really, Judge, the motions didn't really have any merit. I understand that the defense is pro se, but that costs attorney's fees to plaintiff when they have hired an attorney to deal with the motions that did not have any merit. Your Honor, the cross-examination in this case.
I'm going to stop you right there. I know all of that.
Okay.
That was in my decision. That went up to the Court of Appeals. And unless you're going to appeal to the Supreme Court, I can't overrule the Court of Appeals. And I will need the specific factors as they are directing me to go over the 3 times of the compensatory damages that were awarded to the plaintiff. Otherwise, I'm stuck with the 3 times the compensatory damages. The factors in Wisconsin statute 814.045, and I used your letter brief when I did my decision because honestly, that's what I had. And I put in the information that this was, in your words, over litigated, and we had those multiple things. However, that did not appease the Court of Appeals. Therefore, we need more. They need more oomph.
Okay.
Otherwise, again, we're stuck with that other statute, which just says the 3 times.
Then I would suggest and ask that written submission be allowed to this court. I can have it done in 21 days.
All right, Mr. Olsiams.
3 times the statute says 3 times compensatory.
Well, it doesn't say that that's what it's limited to. Is that your argument?
Yeah.
Okay. All right. Well, so I will allow each party to present their arguments based upon the Wisconsin statute 814.045, which does have those specific factors identified, and then look specifically at Wisconsin statute 814.045 paren 2A, which does go into where it states, in any action in which compensatory damages are awarded, the court shall presume that reasonable attorney's fees do not exceed 3 times the amount of the compensatory damages awarded by this presumption, but this presumption may be overcome if the court determines, after considering the factors set forth in subdivision 1, that a greater amount is reasonable. So unless the court can find that it is beyond, it is reasonable to go above the 3 times, then we would be limited to the 3 times the amount of the compensatory damages. I believe that the Court of Appeals decision is quite clear. Quite honestly, I thought I followed that, but the Court of Appeals wanted more, and that's fine. We do what we're told. So I will give 2 weeks for each of you to provide. How about 3 weeks? Is 3 weeks enough?
That makes it, with Memorial Day in there, it helps to have the extra week. So June 3rd.
June 3rd?
That's fine by plaintiff.
Does that work, Mr. Olsiams?
Yes, Your Honor.
June 3rd? and it shouldn't be very lengthy. We're just going over the factors and whether or not the court should follow that presumption of 3 times compensatory damages. All right.
Your Honor?
Yes,
May I say something?
you may.
So I am unaware of all this.
You were not a part of this. You may,
Your Honor, I think she was dismissed.
out of the first action, I believe you were dismissed out of the
Was I
first
a
action.
part of the appeal?
I don't believe you were.
No.
So I think you don't have to worry about that, that matter. You were just involved in the first part, but then you were later dismissed. And then now we're going to go on to the second case in which you are at this time a party. All right, we are adjourned on as to that matter. We will go on the record as to 23 CV 86. Rick Brimacombe et al. Versus Carl Olsiams et al. Appearances are, we have appearing in person, Christopher Anderson, counsel for Mr. Brimacombe. We have Carl Olsiams appearing without counsel, and we have Suzanne Olsiams appearing without counsel. We're set today in this matter for a follow-up hearing to attain additional information for the court to be able to provide its final decision as it relates to this matter. We were set for a motion hearing and a contempt hearing, a damages hearing, and then a contempt hearing as it relates to the underlying issues. It was heard on February 4th, 2025. As the court was going through and trying to prepare its decision, there was some information that was still needed in order to finish or to continue with a full decision in this case. Therefore, I am going to ask the parties if they have any additional information as it relates to the damages. Because I believe that was a little bit lacking. I did get more information in the argument portion from the attorneys. I got some in testimony, but quite honestly, the arguments of both parties, even though I understand Mr. Olsiams is a party / representing himself, that makes it a little bit more gray because a lot of the arguments or information came from Mr. Anderson with regards to the damages. So I just want the parties to be able to either provide a little bit more information as to the damages and or provide counter information to the damages, just so I have a better understanding. So if there are any, if anyone wants to proceed, this was your hearing or your motion, Mr. Anderson and Mr. Brimacombe.
Your Honor, are you looking for anything specific? I wasn't sure, coming up here today, I wasn't sure what the court was looking for the hearing itself. And so we have Mr. Brimacombe here. If testimony is needed, I wasn't prepared for a testimonial or evidentiary hearing, Your Honor. I wasn't sure what the court was looking for.
As to kind of like bullet pointing, you're asking for damages for A, for B, for C,
Okay.
and then the dollar amounts for A, for B, for C, and then what are they? Because it was kind of difficult
Okay.
the way the hearing went
Yeah.
the last time to be able to have testimony and then counter testimony, to be able to put that all together and formulate that into a decision. I could use the arguments,
Can I jump in?
but the arguments are from the attorney / party / attorney. Mr. Olsiams?
Simply, there were no proven damages. They produced no receipts. They just conjecture, guessing. I think I laid that out pretty well in my arguments that they presented no evidence of any damages. They claim.
Well, Mr. Olsiams, and here's so you can understand, the law says that they don't have to have receipts. They don't have to have those things. It can come from their own personal information and their idea. He could say, anyone could say, yes, I purchased this for $59.
Well, they didn't even prove that there was any damage. Not only did they prove no damage, they didn't show any type of compensatory or any type of
And again,
evidence.
Mr. Olsems, that's for me to decide, and I have made certain decisions, and I have heard that there have been dollar amounts stated for certain things. And your testimony and your opposition that there was not any damage. And again, but most of the dollars, I've heard the damages that were being identified, and I heard dollar amounts, but for the most part, the summary of the damages came from the argument of counsel and the opposition in your opposition, Mr. Olsems. And that's why I just wanted to make sure that I heard correctly, unless if there is or there is not.
Yeah, and I can provide the list if you want. I can do it verbally right now, or I can provide it in writing, whatever the court prefers. But I think I can separate it out for the contempt piece, and then I can separate or from the nuisance part and the loss of enjoyment of property and the violations of the law, if you will, for renting the property and running a business on property that they shouldn't have been doing that on.
And that's where I think it got a little bit confusing and a little bit out of order. I'm trying to say this very tactfully.
Say it.
Because it was not a very organized and controlled hearing. And so that's why I need it to be a little bit more organized and controlled. And I like that you have that, Mr. Anderson, but I would need a party to testify to that, and that we can have it as an exhibit, but then we can have Mr. Olsems contest that, and he can provide his opposition to that. But I just need to make sure that I have it all separated, what is being asked for as the contempt versus what is being asked for as the damages portion.
As far as the contempt, Your Honor, Mr. Olsems, or I'm sorry, Mr. Brimacombe can't testify to that. Ms. Haskins and Ms.
I have that.
Rotman, they testified. So the damages that we're asking for there are simply the amount of money that was paid by them to the Olsems.
And I have that.
Okay.
Then we're good with that part.
We're good with that. And then attorney's fees for that, and I have that at $2,970, Your Honor. I can provide additional detail, which I have not yet done. Wasn't sure what the court was going to do with
And
that.
then that's where you're going to have to come in and give me a specific statute that would allow me to provide you with those attorney's fees, because I'm going to follow the Court of Appeals decision, and I'm not going to, unless you have a statute for me that would allow it, as they state, you each their own, carry your own attorney's fees, unless you have a specific statute that would direct me otherwise.
I will get that to you, Your Honor, because it's a contempt. I think the court has the authority to do that, but I will get you the specific statute. I don't have it off the top of my head right now.
Okay. Because I don't want to run into the same issue with the Court of Appeals.
Understood. Understood. So that's on the contempt. You need anything more on that?
No, I do not.
Okay. Then on the nuisance damages, Your Honor, I I can have Mr. Brimacombe go back up, but he testified to
Let me get
out of
to my
pockets.
notes. I have very,
Okay.
as good of notes that I could with the way the hearing went.
Mhm.
So I can go directly to where Mr. Brimacombe testified. Yeah, I'm here. I have his notes right here.
Okay.
So you can present an argument if you wish right now.
Yes, Your Honor. So to start, there was a survey of $2,000. There was we'll call it a repair of the survey because of the removal of the stakes by the Olsems, and that repair was $600, and that was testified to by Mr. Brimacombe at the hearing. Frankly, Your Honor, there's a third time that was not yet testified to because it happened the day of the last hearing on February 4th. And the stake was removed again after the hearing by the Olsems. That is going to have to be fixed again. Your Honor, there are cameras that Mr. Brimacombe testified to. The cost of that, he testified, was $150 per camera, and there were 9 cameras. Your Honor, that amounted to $1,350. And then there was a repair of the camera that was damaged of $150 additional. Lastly, Mr. Brimacombe testified about the monitoring of the cameras being $2,160. The total for those expenses, Your Honor, as I have it now, without the repair or having the surveyor come back out for a third time, was $6,260. Those are the hard costs.
All right. Now let me just double check. I want to make sure that I have my notes.
Can I respond?
You will as when I'm ready. I only have 8 in my notes as the cameras that were damaged.
Well, there was.
That's all I have.
There
in
was
my
only
notes.
one camera that was damaged.
Well, I have,
I just want to make sure we're speaking the same language.
I have trail cameras damaged. There were 3, but 1 was beyond repair. 3 that were close to the property and 1 at the end of the driveway.
And only the one was the one that required cost, Your Honor, to fix.
So there was only 1 that was really damaged.
Yeah, one that had to be replaced. It was damaged beyond repair, I should say.
All right, Mr. Olsiams.
None of those are a survey is not a damage. Repairing a survey marker doesn't cost $600 and is not damage. $1,350 for cameras. There was only one camera that they testified that was damaged, and again, there was no proof that I damaged any camera or Suzanne damaged any camera. Monitoring of cameras, that's not damage either. Again, Your Honor, I just want to point out that this is not a real case. There's no damages. What they're basically trying to do is to get us to stop renting our property. They didn't provide any evidence of any damages, much less that I damaged anything or Suzanne damaged anything. These are pie in the sky, not damages. They're just numbers. Survey is not damage. Repairing a stake is not damage. And there's no evidence that I damaged the stake. There's no evidence of anything here. It's just all conjecture. There are no damages. Again, I would ask that their claims be dismissed because there are no damages here. Surveys aren't damages. Repairing and putting a stake back in the ground, it takes somebody to take a hammer and pound it back in. And again, there's no contempt. The county ordinance says 10 days or less.
We don't need to get into the contempt.
Okay.
We're not there. All right, thank you, Miss. Miss Pesco? Alsiums. I can't remember what your maiden name was. I'm sorry.
Beskar. Yeah.
Beskar. Miss Alsiums, do you have anything to say?
Other than I, as testified, was not involved, my name.
You don't have to say anything. You can say, just you're relying on what you stated the last hearing. All right.
From that. Thank you.
Unless anyone wants to provide any additional sworn testimony, I think I have it. I just needed to make sure that I had what was stated at the last hearing and compare it to my notes to make sure that I had what was being asked for, because there are other things that were testified to that could have been damages, but they were not being asked for in a monetary amount, such as no trespass signs, and then the damage to that easement road, those types of things. But then there were non-monetary, I guess, there was no dollar amounts requested. So I just wanted to make sure that I was on the same page and that.
So Your Honor, may I respond to what, maybe I don't need to respond to the specifics of what Mr. Alsiums just said, but obviously we believe that they are damages. You have to get a survey to keep people out your property.
Correct.
Okay,
Yes.
I don't, you understand our side on that?
I understand both
Okay.
sides.
The last piece, though, Your Honor, that I did not address, I was trying to take them in pieces, the hard cost, but then also the fact that my clients have lost the ability to enjoy their property while there are 15 vehicles and 18 people running around.
Yeah, I understand that stuff. I just needed
Alright.
to understand if nobody's seeking any monetary amount for any of the alleged timber trees that were cut, that damage to that big tree that was talked about, the no trespassing signs, the damage to the easement road.
That's because there were no damages.
I'm not talking to you. But, and the fact that there were perhaps discarded waste allegations, but for those alleged actions and alleged damages, there's no monetary amount sought. Is that correct?
It is correct with respect to a specific dollar amount, but all of that goes to my client's inability to enjoy their property to a certain extent. And those numbers are in our submission to the court from our closing argument and go to basically my clients having to be the caretakers up there when the Alsiums are 100 miles away, which I put in my brief is also a violation of Burnett County ordinance. And so all of that, Your Honor, goes to my clients basically working when they're up there at times, dealing with renters who are asking them questions, who are getting stranded on the lake, et cetera. And so all of that, again, goes to the $630,000 of ill-gotten gains that the Alsiums received because they were running a business when they shouldn't have and where they shouldn't have. So there aren't specific dollar amounts that go with those, Your Honor, but it's all part of the overall claim that is my client's inability to enjoy their property and have this serene, tranquil experience that they expected when they went up there.
Okay, Mr. Alsiums?
And again, that's nonsense. It's only a few weeks every summer. There are no damages. Again, they're just reaching. They're just basically trying to get us to stop renting our property. Not enjoying your property. Again, he was able to go to the property. He's able to get to his property. There weren't 15, again, the evidence shows there weren't 15 cars parked there. So again, this is all a reach. There are no damages. There's no contempt. And I've been in compliance with the 10-day order from last year and this year as well.
Okay, thank you. Now, the only other thing that I'm going to need then to wrap this all up is the argument for attorney's fees. And if you believe that attorney's fees should be granted, and if you believe that they should not be granted. Mr. Anderson is going to argue that they should be granted, and he's going to find a statute that says that there's authority to do so. And would you like to have Mr. Anderson file first and you do a response, or would you like it to be a dual filing, Mr. Alsiums?
He can file first.
Okay, So, Mr. Anderson, do you believe that you can have both of your filings by the 3rd, or do you need additional time?
Third's fine.
All right, so have both of your filings by the 3rd. And Mr. Olsiams, your 21 SC case will be due the 3rd, but your attorney's fees matter will be due on June 10th. Is that okay? Or would you need another, or would you need till June 16th or 17th?
June 17th.
All right, so June 17th, your response can be due, okay? So then that would be the last thing to wrap all of this up, and then I will have everything I need to complete my decision. Okay? All right, thank you.
Your Honor.
I think that's all I.
Well, she cut that off very abruptly. All right. Well, I just put up a poll. Where should we go next, Florida or Louisiana? But nobody's really had a chance to vote on that completely. So where we'll go next after we watch a little bit of Judge Middleton. That's what that poll will mean.
But I'd like you to stop out at the counter about that unpaid stuff. Maybe set up a payment plan to pay it.
Yes, sir, Your Honor.
You're usually, not usually, you're always here when you need to be, and you've paid off a bunch of old stuff. I'd like to get that one taken care of as well. All right, you stop out at the counter, find out about what you owe, and I'll see you next Tuesday at 1 o'clock.
Yes, sir, Your Honor.
All right.
You got my number?
No, sir.
All right, don't worry without getting my number.
Yes.
I can give it to you at the court.
That would be May the 20th. 1 p.m. All right, thank you. John Heath from Cassopolis is not here. Would you call a hall for John Heath?
Nobody out there, Joe.
All right. John Williams Heath, third, charged with resisting obstructing a police officer, posted a bond on May 2nd. Did you ever have contact with him?
He left me a message and I was unable to reach him when I returned it. I've known the boy for several years now. Suspect he's in the Three Rivers area, but I've had contact beyond that message.
We're gonna do a bench warrant. Original bond was 5,000 PR. We'll make it 5,000 cash or surety. 48-hour hold. That's not my idea. That's a thing that the state legislature told us we need to do. So if anybody knows John Williams Heath from Three Rivers and or Cassopolis, he needs to get hold of his lawyer. All right, should we zoom in Eric Austin?
It's fine by me, Judge.
All right. Do you have a thought on that, Josh?
No.
Let's bring him in, and then while we'll get the room open, we'll also take care of that misdemeanor dude, Mr. Wigington.
Judge, I've got Mr. Hamilton here. There is something regarding his bond conditions that we'd like.
All right, well, let's talk about that. I'll dial this guy up anyway.
All right, looks like the audience has spoken. I'm
Good
going to go
morning,
ahead
Brooke,
and
Judge
end
Middleton
the
calling.
poll. 62% of you say we should go to Florida. So let's look at going to Florida. This is Bay County. This is the 14th Judicial Circuit. This is Judge Brantley Clark. I've got no idea what they're doing in his court today, but we're going to find out together.
Were you aware of the alleged victims last? You look well. prosecutor of that.
Good idea.
You know, Center for Trauma Management and. I want to.
My first case on the docket, Judge, that's 24-2094 CF. I've spoken to the prosecutor, JP Ferreira. We'd like a continuous date on that because we're negotiating possible settlement. A couple of months, you want, or I'd like 1 month at least. The other case that's on your docket, Judge, is Didda Johnson. That's a murder case. It's 22-246 CF. I've spoken to Frank Sullivan, the prosecutor. Mr. Overstreet has communicated with him, so I'll defer to Frank. Thank you, Frank. I think that's it for me today, Judge. All right, yes, sir. Thank you. Do I need to sign anything, Madam Clerk?
Good morning, Your Honor. I'm before the court in the state of Florida versus Lucas Gavin Manger, case number 24-3118. I believe we have a resolution, Judge. They need to check with the victim, but if it's resolves as I anticipate it will, we won't have to come back. So it really doesn't matter what date you put me on. I'm going to be optimistic.
The PTI.
That's the.
All right, June 10th, enough time?
Yeah.
June 10th at 9 o'clock. Lucas Mangler, 24 CF 3118. Is that all? Ms. Anderson? Oh, yes, two more.
Jackson, you doing good? Yes, sir. How are you doing? It's good to see you. It's good to see you too. Yeah, I'm fine.
Brian's got green. Brian, do you also have Cody Sanderson?
Chicken?
Cody Sanderson?
No, not that I'm aware of.
I've got I think I have a signed plea. I thought it had already been entered, but let me just get him on another date and sort it out when I get back to the office.
Who's that now?
Cody Sanderson.
What do you want to put it for?
Just next, your next court date.
June 10th?
That'll be fine, Judge.
At 9 o'clock. You need to talk to me.
Shots.
I did have a resolution until
Nailed it. About 7 short of quarter.
The first case I have is Dennis Ray Biddy, BIDDY, 25-4 CFMA. And I believe we have all the discovery, Judge. I just need to get up to date on it. If we could maybe go to a July pretrial.
Yeah, July 15th at 9 o'clock.
Biddy, BIDDY.
July 15th at 9.
And the next case I have is Johnny Goodwin, Goowin, 25287. And it appears that we have all the discovery and we've got an appointment scheduled with the client to go over a plea offer. Maybe we can have that wrapped up by the July 15th date.
July 15th at 9 o'clock.
And the next case is Ryan Haas, HASS 24-4108. And it looks like we do have all the discovery in the case. Judge, I just have to get up to speed on that. If we could go to 7:15.
July 15th at 9 o'clock.
And the next case is Janet Milam, MILAM 243999. And Your Honor has just signed a motion for the DCF to disclose the records that are applicable to that case. If we could go to 7:15.
7:15 at 9 o'clock.
And the next case is Destiny Mitchell, MITCHELL, 2 case numbers 243828, 243899. And if we could go to 7:15, I should be able to get a handle on where we are in that case.
July 15th at 9 o'clock.
And the next case is Edward Coley, COLEY, 25329. And if we could go to 7:15, I'll have a handle on that case by then.
July 15th at 9 o'clock.
And then my last case, Your Honor, is Bradley Tennell, 241693. We had some deposition dates in that case, but we are still awaiting some of the public records requests that we've made to the sheriff's office. They reached out to me last Friday and said that they're still in the process of gathering the records. So we're still in discovery. If we could go to 7:15 on that one.
July 15th.
Thank you, Judge. That concludes my business. Thanks.
Hanson?
I'm here for Stephanie Smith, case number 24CF3100. We have 2 sets of depositions scheduled, one for the 15th of this month and another for the 27th of June. Your Honor, I think if we can get the July 15th date, we ought to have enough to know where we're going.
Any objection?
No objection.
July 15th at 9 o'clock.
That concludes my business, Your Honor.
Yes, sir. Mr. Ramey?
Morning, Your Honor.
Good morning.
Mr. Henson.
Your Honor, may it please the court, I have several cases with you this morning. First case is with Mr. White, State of Florida versus Robert Bond, BOHN, case number 224999. I sent Mr. White a letter yesterday indicating what discovery that we still don't have. We have depositions scheduled on August the 11th, hopefully to finish up. And we'd like to put on a trial management date for your August term.
But for a trial in August or?
No, sir.
Okay, this seems mostly procedural there. As I am wont to do, I like to try new courts, especially now. This is one I'll keep an eye on. But let's go to Louisiana. This is Board of Pardon and Parole, and they are doing revocation hearings.
Revocations this morning is at Jefferson Parish Correctional Center. Good morning, sir. Would you introduce yourself?
Good morning. Deputy Marlboro with Jefferson Parish Sheriff's Office.
Great, thank you, sir.
Carter.
All right, thank you so much for accommodating us this morning. Is Mr. Carter there?
Yes, he is.
Right. Where is he? There he is. Good morning, Mr. Carter. Would you
Good morning, ma'am.
Good morning.
Ladies and gentlemen.
Would you introduce yourself? Tell us your name and DOC number.
My name is Chico Ahmed Carter. My DOC number is 389-108.
All right, yes, sir. And just want you to know, and I guess you can see your mom is here, and she, well, I guess she's there. No, she's at probation. She She wants to speak on your behalf, and we'll ask her for her comments in just a moment, but we're here for a revocation proceeding. Do you have the revocation questionnaire there in front of you? You have a form there?
Yes, ma'am.
Is that your signature at the bottom of that page?
Yes, ma'am.
So based on your answers to those questions in that questionnaire, you're not eligible for appointed counsel. So are you ready to proceed without counsel this morning?
Yes, ma'am.
All right. Your case has been assigned to Mr. Freeman, so I'm going to turn it over to him to read the allegations.
Okay, Mr. Carter, I'm gonna read the allegations and you to plead guilty, not guilty, with or without a statement. And then we'll discuss the matters once I finish reading all of the allegations, okay?
Yes, sir.
Okay, you were engaged in criminal activity when you were arrested on January 30th, 2025 by the Kenner Police Department for 2 counts of misdemeanor domestic abuse battery and 1 count of felony domestic abuse aggravated assault. You pled guilty under the Alford plea on March 26, 2025. How do you plead to that charge?
Guilty, sir.
Okay. You were ordered to pay $63 per month in parole supervision fees starting on May 1st, 2024. You have not made any payments on your supervision fees and are currently $567 in arrears. How do you plead to that charge?
Guilty, sir.
Okay. So, I mean, what's the basis? You pled guilty to the violations. I mean, where am I to go from there?
I mean, I thought that if that's what I pleaded on the paper, that's what I should plead.
Yeah, that's true. Tell me what happened.
Well, sir, well, what happened was, my ex-wife, you know what I'm saying, for about 20-something years, you know, came to my house, came to my address, and when I walked out to the car, and I leaned in the car like normal to talk to her, and when I leaned in the car, I seen her flash a hammer. And at that point, when she flashed the hammer, I grabbed her hand. I grabbed her hand with my right hand because her hand was on the passenger side of the seat with the hammer. And I grabbed her hand. When I grabbed her hand, she went to trying to attack me as well, which I have all the bruises on the pictures where she scratched me up. Now I'm trying to defend myself from not being hit with this hammer. And at this point, you know what I'm saying, I'm wrestling with her not to be hit with this hammer. So when I come out of the car, she stands up and my mom, and at this time, I guess my mom, she's standing between, and I snatched the hammer from her hand because I feared for my life. I didn't go out there to do anything to her. When I sat in the car to talk, not to cause any problems. But when she showed me the hammer, that's the second time she came to that address with a hammer to attack me. The first time, you know what I'm saying, we took the hammer, I gave it to my mom, and my mom put it in the house. This second time, you know what I'm saying, I lean into the car, you know what I'm saying, I'm talking to her, and I just see a hammer come up. Why would you bring a hammer to just if you come to talk to me? So automatically I fear for my life.
Yeah.
And at this time, yes, sir.
Go ahead. So at this time, what happened then?
At this time, you know what I'm saying, as I'm holding her, first I'm holding both hands because with the hammer with both hands. And then I take it away because she's attacking me with the other hand. She's attacking me with the free hand. Actually, her left hand, or no, her right hand is on the passenger seat. You know what I'm saying, with the hammer in it, covered up with a shirt. And when I'm leaning into the car like this here, like I'm sitting on the edge of the car, leaning in the car. So when I'm leaning in the car, when I grab her hand, she's attacking me. You know what I'm saying?
Got all that, yeah.
Yes, sir. So when I step out the car, about this time, you know what I'm saying, I think my mom stepped into the way, but at this time I'm more focused on this hammer in her hand that I snatched out of her hand. You know what I'm saying? But this time, you know what I'm saying, I think in the process of me snatching the hammer out of her hand, my mom was bumped. She wasn't hit. She was bumped. You know what I'm saying? And at this time, I think my mom snatched the hammer out of my hand. Now, as I read on the paper, she got allegations that I was punching her in her face. Sir, and if you look at the pictures in the camera, she have no bruises on her at all. Nobody have bruises but me.
Okay. What did your mother have to say? And then I might have some questions for both of y'all.
What do you mean, sir?
It's fine. It's okay.
Okay. So what do you want to say about your son?
Well, I've never known him to beat up on no woman. I raised my boys. I don't appreciate no one man putting their hands on no woman, period. And majority of what he was saying is exactly how it happened. But I can start from the beginning and go right up to the point where she left. And when the police came in and when I talked to him, I went to grab my son to stop him from getting into a fight with her and stuff. And in the process of doing that, when he went to hit her, I grabbed him and he hit me with his elbow as he was coming around like this in front of me. She was like this on the back, like laying down on that seat. And I thought he had the hammer, and that what really scared me. But she had the hammer, and I did not know that she had the hammer until she told me, Miss Pat, he don't have the hammer. I got the hammer. I said, yo, no, you can't do that. Give me the hammer. And that's when she put the hammer up under the seat of the car. I grabbed him and pulled him to me and kind of like turned him around because I didn't want him to go nowhere over that area again. Nowhere. And that's what it. And like I told him, you know, you don't need this. You don't need this. All it's going to do is get you in trouble. Just give her her keys or give them to me and I'll give them to her. And they were just word for word with different things. But not one time did I see him actually hit her at any form of fashion.
Thomas
All I
Carter,
know is
did your quote?
I
I'm gonna
was
read
hit
your quote. Now
that
you gonna
way.
tell me the truth?
Huh?
You gonna tell me the truth? Because I'm gonna read what you said.
I'm
And you said
telling
he
you
was
the
hitting
truth.
her. And if a man would hit you like that, it would have been murder.
I said if my son, when they said that my son hit me, if my son would have hit me, y'all would lock me up in jail because I'll pull one of them pipes out there, y'all, and beat the living hell out of it.
That's what you
I
said.
don't believe in that.
Okay, well, that's your statements are not matching up. You said Patricia Carter observed Chico Carter push LaQuina Smith back in her vehicle. Patricia Carter approached Chico Carter and took.
Wait. Excuse
Patricia
me.
Carter observed LaQuina grab the hammer.
I'm not telling nothing about
Carter took the hammer from her mother. So you took the hammer from him, and then
No,
you stepped
I
in
took
between.
the hammer. I took the hammer from Quincy. Quincy had the hammer. Quincy put the hammer under the seat in the front. She put it in the front up under that seat, like going to the back of the car.
Okay.
And I'm standing right there by
I'm
the
gonna ask you
door.
one question. And you tell me the truth. Okay? While speaking, well, it should be noted that Patricia Carter advised that if a man had hit her like he was trying to hit her, we would be arresting him for attempted murder.
She would have arrested me for attempted rape.
Okay.
I did not say
probation
arrest.
officer, do you have anything to
Sir.
say?
I do not. I'm just assisting her with the Zoom meeting.
Okay. Good to see you.
So, okay.
Okay.
I'm not gonna sit up here.
I just had to ask you questions. I can't hear you. I'll cut her off. Okay. All right, put him back on. Okay, I'm ready to vote. I have no further questions.
All right, Mr. Freeman,
I vote to revoke, due to his offered plea of guilty.
Mr. Prater.
I concur.
And I do as well. My vote today is to revoke based on your guilty plea. So today, Mr. Carter, your parole's being revoked. Good luck to you, sir.
Ma'am.
And Ms. Marlboro, that concludes our business in Jefferson. We're signing off at 8:59. Thank you so much.
Okie dokie. So that's what went on there. Let's go back to Judge Middleton's court, I think.
to be considered for the other GPS alternative. I think there's a kind of like a handheld or a cell phone one. He doesn't have a criminal record. He's got strong ties to the area. I don't think he intends to depart anytime soon. So I'd ask the court to consider that option.
Where do you work?
I work down in Indiana, J-Code. I build RVs.
I knew a guy that worked at one of the plants. I won't name it. He was one of the managers there. He said half the guys on the shop floor are wearing a tether on their leg. So why can't you do your job wearing your tether?
I work in floors in the back, and I'm required to wear boots because of all the, like metal and heavy lifting stuff. Like precautions so it don't fall on you. Type of deal.
I'd also note that he does own a home in this area, so he's got a property and monetary interest in.
I'm not worried about him not showing up, but I'm worried about young kids with guns. We got 4 of them today. There's a prelim this afternoon where a guy's mad at some other kid, so he's blam, 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 blam right through the car door. This young man isn't gonna abscond, but it's more of a public safety issue. They say he likes guns. Had to do with a girl. According to one of the witnesses, Mr. Hamilton placed a gun against his girlfriend's neck at some point after 3 victims had left the residence. I could amend your bond to just put you in jail, and then you wouldn't have to worry about wearing a tether. So you're a blessing by having a tether rather than sitting in the county jail. So you can struggle through with this tether.
And is it okay if I put the offer on the record?
Yes.
So an offer was made of 1 count of felonious assault, 1 count of CW, others, and found felonious assault with felony fire attack, and say that our office will not be dismissing that. And he will be looking at a mandatory 2 years in prison.
Probable cause search of his truck resulted in the seizure of a tan and black semi-automatic 9mm pistol with an obliterated serial number. The handgun was unloaded underneath the driver's seat where Hamilton was seated. A loaded 9mm magazine fitting the pistol located under the seat was found in the center console of the truck. Also, several 20-gauge shotgun shells were located in the center console of the truck, along with an unloaded AR-15 rifle on the rear floorboard of the truck. Furthermore, 2 .450 caliber unspent bullets were located in the rear driver's door area. We'll leave the bond as it is. And we'll see you next Tuesday to see whether you wish to have a prelim or waive it. And you can talk about that with your lawyer in the meantime.
Thank you, Your Honor.
Thank you.
Call in the next couple of days.
You have a blessed day.
All right, thanks. What's your question?
A waiver for a towing fee?
I don't know anything about it. I don't have the ability to do that. Who asked you about that?
Well, we currently had, we were pulling a trailer, a camper, and it had fell off my hitch. And we went to go get help to help it, put it back on my truck. By the time we got back, the cops were there and they called it over and they had it towed. But I had Googled it and it said that there was a waiver for towing fee.
I'm not aware of it. You could challenge it with a TR 25752 if you allege it's an improper tow. But I don't have the authority of the court to waive a towing fee. Especially for someone that's not charged with anything. That's between them and the private company. Sorry, I just don't believe everything you read on Google. Maybe that's another state.
Yeah, Bailey, what you're talking about with him bringing up other cases and stuff, I've noticed that too. I think it's just a function of who he is and where he lives. He literally knows everybody in that community, so there's, I think, naturally just a lot of crossover in his mind. He's just, again, he knows everybody and everything they've ever done. I'm not saying it's right or wrong, I just think that's why it happens. All right, so I have been playing around here to get us set to go to Judge Simpson's courtroom. We're about 15-20 minutes in the Wayback Machine. I'm close to where this needs to be. This is a preliminary exam. There's a couple of occasions where he mutes for a second, but this looks intriguing from what I could see, so we're going to watch this for a little bit.
4th of June, which would 24th. June 24th, 2025.
You don't have
Then this is all messed up. What? Oh, I can't. You're right.
Correct. You have the 17th in the afternoon.
I have the 17th of
Yes, of June, because of Juneteenth. So it's PMs.
Oh. Hang on a minute. June 17th, 2025 at 12 noon.
Would the court consider just a nominal bond in the event if he were to be released?
So this is just a minute or two ahead of when this preliminary exam starts, so just bear with it.
Obviously, we will work to rid him, but I don't know. He may get out of Mineral County Jail between now and June 17th.
Let me respond.
A very, very nominal bond. Like $10.
Brown, when have you ever known me to set a $10 bond? I think I did once. Still haven't seen that person. I'll set bond in both cases at 1,010%.
Thank you.
Thank you. Well, are we ready to go on something? Johnson's over there hiding in the corner. He's ready on this?
Yes.
He was over there hiding, but I saw him.
I'm not hiding, I'm just staying out your way.
What? Staying out my way? Why? I am one of the most enjoyable people I know.
Yeah, Ashley, Bailey, I agree. I like Judge Simpson a lot too. Interestingly, as I'm paging through looking for what I want to show you this morning, you know, I get shown other court channels, and it seems like the ones who were Judge Fleischer channels are all running to Judge Simpson now. So it seems like the next go-to for everybody.
Gaddy is off today, so he's not here. So.
Is he counsel approach? versus Lawrence Buckner.
Andrew Childers appearing on behalf of the people, Your Honor. Good morning, may it please the Honorable Court, Kareem Johnson, appearing on behalf of Mr. Buckner, approaching and seated to my right.
State your name, sir. Thank you. All right. Date and time set for preliminary examination. You may proceed.
That's correct, Your Honor. The people are ready to proceed. We intend on calling one witness. Maybe the people call their first witness.
You may.
We would call Amy Hudson to the stand.
See you on the phone again. See you on his phone or no? Because you did that at the. Pardon? Council approach, please.
Well, that's not starting out promising for him. I don't know what he was doing on his phone, if he was trying to record or, you know, play Wordle or what, but we'll see where this goes.
Yeah, raise your
right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? State and spell your first and last name for the record.
My name is Amy. It's A-M-E-E. My last name is Simpson. G-A-S-O.
All right, you may inquire.
Thank you, Your Honor. And just one other matter. My officer in charge, Deputy Von Heath, is present in the courtroom. He's the only other witness I have present. I don't intend to call him, but he is present.
All right, good.
Miss Hudson, directing your attention back to the date of April the 1st of this year, 2025, were you in this courthouse testifying in a preliminary examination on a different matter?
Yes.
Okay. And was that in this very courtroom, courtroom C?
Yes.
Okay. And who was the judge at the time? Judge Washington? Okay. And was the defendant in that case, based on your understanding, Ms. Hudson, Mr. Buckner?
Yes.
Is he present in the courtroom here today? Yes. Can you identify an article of clothing that he's wearing?
He's wearing a black.
Okay. Your Honor, may the record reflect in-court identification of the defendant?
Without objection, record shall so reflect.
And I don't want to get into the facts of that case, but you were some sort of witness in that criminal case. Was that a criminal case?
Yes.
Okay. And you were a witness in it?
Yes.
Okay. And had you testified before Judge Washington in that matter on the date of April 1st, 2025?
Yes.
Okay. At some point, were you done testifying?
Yes.
Okay. After you were done testifying, what did you do?
I went and sat back down while they called up the next witness.
Okay. Where did you sit down?
I sat about where I was sitting when I stood up today, maybe one row up.
Okay. So we're making a transcription of this. So I'm going to have to be.
It's on the right-hand side, probably the third row back.
You're pointing in the courtroom. So you remained in the courtroom?
Yes, I remained in.
Okay. So you sat down in what we would call the gallery of the courtroom from where you are sitting in the witness stand on the right-hand side. And you said about the third row back.
Third row back.
Okay. And you did that while another witness was testifying. Okay. And at some point in time, did that witness stop testifying?
Yes.
Okay. What happened after that witness stopped testifying?
The judge asked for some more information and then she called for a break.
Okay. The judge stood up to take a break? Okay. Is that a yes?
Yes.
Thank you.
I'm sorry.
It's okay. And what happened when the judge stood up to take a break?
When they called the court for recess, he was on the left-hand side.
Who is he?
Mr. Buckner was on the left-hand side. He stood up. He was around two people that had already started to be in the row.
I'm going to just stop you right there. So you've said the left-hand side. That would be the left-hand side of the courtroom from where you are seated in the witness stand today.
Yes.
Okay. That would be the side that the defendants normally sit at?
Yes.
Okay. Was the defendant, where was the defendant seated?
He was in the first row back.
In the gallery?
In the gallery.
Okay, so he was not seated at counsel table?
No.
Okay. So the judge, the judge got off the bench and exited the courtroom?
Yes.
Okay.
Yeah, the judge, she did not exit the courtroom right away. She stood up, as they were calling. There was two people up front talking to her. And then when she got done speaking to them, that's when they called the recess. And he stood up.
He being the defendant?
The defendant, yeah. Went towards the middle. There was two people already going to go to exit. He waited until the sound went out.
Okay, when you say how do you know he waited until the sound went out?
Because he turned around and he looked. He stopped.
Objection, speculation.
I'm gonna overrule the objection. I'm gonna let her.
He stopped. He looked back. The minute
Hold on. Look back at
the
where?
screen. He looked back at the screen to make sure that the judge.
I'm gonna just,
Okay.
I'll stop you there. We're gonna unpack this a little bit. And Judge, I understand the court's concern. So you observed the defendant. You said he stopped. Where did he physically stop?
In the middle.
In the middle aisle?
In the middle of the aisle.
Okay.
Yeah.
Where was he in the middle of the aisle, close to what we would call the bar or close to the back door of the court?
He was in the middle, like closer towards this side of the
Your motion, the right side.
The right side.
Okay.
Yes.
But I'm asking you, distance wise, was he in this area or was he in the back part of the?
No, he was closer towards
The front, okay. You are still, fair to say, you are still seated in the third row
I'm still seated.
on the right, your right side of the courtroom.
Yes.
Okay. When the defendant stopped, is he looking at you or is he looking somewhere else?
When he first stopped, he was looking like straight ahead.
Straight ahead.
And then he
And
Straight ahead toward.
Yeah.
towards the exit door.
Towards the exit door.
Yes.
Okay.
And then when he stopped, he turned around and he looked.
And in what direction, when he turns around and looks, in what direction is he looking?
He's looking to see if the judge is.
I'm not, and so I'm not asking you. You can testify to things that you see, things that you hear, things that you witness. You can't testify to what someone else is thinking.
Right.
Okay.
No, he
So,
turned in the direction as to where the judge stand is.
okay. So just so we're clear, the defendant was looking towards the back doors of the courtroom. He then turned around and is looking in the direction of where the bench and the TVs are.
Yes.
Okay.
Yes, the bench and the TVs are.
At some point, does he then turn back around to look towards the back door?
Yes, he does.
When did he do that?
The minute the screen started making that sound.
Like a whoosh, white noise sound?
Yes.
Okay.
Yeah, like
And
it's no longer.
And I will direct your attention right.
Okay, go ahead.
I'll direct your attention right now. There are screens on in this courtroom.
Yes.
You see those?
Yes.
And they're depicting the court and yourself in the witness stand. Is that correct?
Yes.
Okay. Did the screens look like that when the okay. What did they look like if
They
you look?
were like, as if cable went out, they were, there was nothing there. It said private.
Okay, it said private.
There's a black screen with private written in white.
Yeah,
Okay.
yes.
At that point, once the screens changed from showing the video of the courtroom to this private, what did the defendant do?
He walked on to the right-hand side, stopped to where I was sitting and made verbal threats.
Okay, he said something to you?
Yes.
What did he say to you?
He called me.
I'm going to stop you right there.
Yes.
Hold on a moment. You mentioned something and I just need to clarify this. You said that there was static.
Yes, sir.
What was that you're talking about?
There was no more pictures showing. It was just a like when you call up the lawyers to speak to you, the screen makes a noise. It makes it makes a noise. I don't know how to describe it. It's not a silent noise. It makes a noise to where it's not recording anymore. Do you want me to sit down so you can turn it off?
No. Pretty much here every day. I'm just trying to figure out what you're talking about. You're saying it made a noise.
Yes, the screen went blank, and it's not like it's crushing out a noise. Like there's a noise
Coming out of the speakers.
Yes, coming out of the speakers.
Was it a constant noise?
It started, and then I'll be honest, I don't know if it was coming on.
Gotcha. Okay, just one other thing.
That's fine.
When you said Judge Washington was talking to two people, was she talking to two people in front of the bench or two people behind the bench?
No, two people in front.
So she was speaking to two people in front of the bench. All right. At the point at which she's doing that, can you hear that conversation?
No.
Okay, at the point at which she's doing that, do you hear anything in the courtroom?
No. I mean, I can hear people talk, but not up front. I mean, just what, people may be saying as they're sitting on the gallery.
Right, but do you hear anything else?
No.
Okay. And she had that conversation and then turned around and left.
Yes. Yep, they call
At the point that happened, what was on the screen?
Before, when she got done speaking to them.
Not as she's talking to them. What's on the screen?
There's nothing on the screen. And then she got done speaking, and the video came back up before they called recess.
And when you say the video came back up, the video like it is right now?
Yes, and it just showed her on the bench. There was no one on the stand.
Okay, go ahead. So at some point, as we've discussed, the defendant then turns and is walking, now facing back towards the back door, which would also be in the direction that you are in relation to the defendant.
I think he's just recapping what she's saying, so I'll overrule that. Go ahead.
Yes.
Okay. And you had previously said the defendant said something to you.
Yes.
Okay. What did he say to you?
He called me a lying bitch and told me that he was going to get even. He was going to get me. That was the last thing he did. He was going to get me.
Did you say anything in response to that?
No.
How did that statement by the defendant make you feel?
Correct.
After he made that statement to you, where did the defendant go?
He turned around, looked back one more time.
I'm going to stop you there just so we're clear. So at the time he's talking to you, is the defendant looking towards the back of the courtroom or the front of the courtroom?
He's looking looking at me.
Right.
At the exit.
Okay, so he's facing away from where the judge would sit.
Yes.
Okay. After he makes that statement, you said he turns around?
Yes.
Okay. When he turns around, in what direction is he now facing?
He's facing back towards the front where the judge would be sitting for this area.
At the time he turns around, is the judge on the bench?
No.
Okay. If you recall, at the time he turns around, who would be on and I'm motioning on the other side of the bar, who were there attorneys or people present?
Yes,
Okay.
His lawyer was still on the left-hand side. You guys were still on the right-hand side.
You guys being someone from the prosecutor's office? Okay.
Yes. And there was one officer also on the right-hand side, and there was one officer sitting out in the gallery, like up from me.
Okay. So the defendant makes a statement to you. He turns around and he's now facing back in the direction of where the judge would sit. And what happens next?
The minute he saw that his lawyer was coming out, he turned around and took out the exit door.
Okay.
So again, speculation of what my client saw. Okay, I would agree. So his lawyer, what you saw, ma'am, was his lawyer starting to leave and then he left.
Yeah. The minute
That's what you, no, that's what you saw.
Yes.
Okay, thank you. I think that corrects it. That's what, go ahead.
And did you remain seated in the gallery of the courtroom or did you exit the courtroom at that point?
I remained seated.
Okay. And at some point after this fact, did you bring what had happened to someone else's attention?
Yes.
And who was that?
It was one of the police officers.
One of the police officers present in the courtroom?
Yes.
Okay. After you made contact with the police officer, did you have any further interactions with the defendant, Mr. Buckner? Okay. Certainly not in the courtroom.
Right.
Correct?
Right.
Okay. Anything in the hallway of the courthouse?
No.
Okay.
No.
Mayor, one moment, Your Honor.
Ma'am. While you do that, ma'am, you said you were seated in the third row. How far in on that third row were you?
Right there where the gentleman is with the black sweatshirt.
So you were seated on the end
Yes.
toward the aisle.
Yes.
Okay.
I have no further questions, Judge. Thank you.
Cross-examination.
Okay, ma'am. So you were here to testify, and if you remember, was that in case number 25 FB 1106, if you know?
I have no idea.
Did you get a subpoena to come to court and testify in that
No.
case? In that case.
I did not get a subpoena.
Okay.
They asked me to come and testify.
Now, it's my understanding that you're indicating that you are
Picking
seated
him out. Picking him out.
in the gallery of the courtroom right here.
Wow. Okay. Yeah, gotcha.
Is that correct?
Yes.
And you said that there's a member of law enforcement 2 rows up, sitting right here, where there's an individual with a sheriff's shirt.
Yes.
And your testimony to Mr. Buckner comes down the hall, the aisleway, stands at that same pew where the law enforcement officer was and issues a threat to you, which would have been within 15 feet of the law enforcement officer.
I never said that. I said he stopped at where I was sitting and said something to me. I never at any time said anything that he stopped where the police officer was sitting at the pew.
So when he stopped, he was at your row.
Yes.
But there was still a law enforcement officer 2 rows up.
Yes.
Was there other law enforcement officers in the courtroom like there are today?
One sitting up in the corner, up here on the right-hand side, where the gentleman is with the glasses.
When any of, I'm sorry.
Sitting where?
The gentleman with the glasses over here?
Mr. Bird?
Yes. That's where the other.
Oh, on this side. On this side?
On this side.
On the right. Okay,
Yes.
go ahead. Go ahead, counsel.
When this statement was allegedly made, none of the law enforcement officers in the courtroom jumped up and said anything?
No.
Now, you indicated that after you testified, you stayed in the courtroom.
Yes.
Was there a sequestration order that, was there an order that you leave the courtroom after you finished testifying?
No.
Okay, so you heard the testimony after your testimony.
Yes.
Mr. Buckner's lawyer at the time challenged the accusations that you made regarding Mr. Buckner, correct?
In which case?
In the 25, in the case you were there to testify about.
Your Honor, I would object to what that other lawyer did. That would be hearsay.
I'm not asking for
Well,
what.
she's asking, I'll overrule that. I mean, he's not asking what she said. He's just asking what her impression of what he did.
Right.
So go ahead.
His lawyer in the case you were there to testify on was challenging you on the assertions, allegations you made about Mr. Buckner.
For that case?
Yes.
Well, I mean, I don't know if he was challenging me, he was just questioning me the
Okay.
same as you are.
And there was another witness that came up to testify after your testimony, correct?
Yes.
You heard that witness's testimony.
Yes,
You were there when the preliminary examination ended, correct?
yes,
That Judge Washington, found that there was no probable cause that Mr. Buckner committed a crime. Correct. Well, Your Honor, the relevance is they've charged my client with intimidating.
I'm going to overrule the objection.
Yep.
Go ahead.
Judge Washington found that there was no probable cause to believe that Mr. Buckner committed a crime after you testified, correct?
she also stated that it can be called back up if they get the proof that they need.
Okay, which is fair. All right. So after you made accusations about Mr. Buckner pointing guns at people, correct?
What does that have to do with this case?
Ma'am, I don't
Answer the question, ma'am.
Yes, I did.
You made accusations that you saw him deliver crack from a great distance away. You didn't make the accusation? Did you make an accusation that you saw him point a gun at somebody?
Yes.
Okay. No further questions, y'all.
I have no redirect, Judge. Thank you.
All right. Ma'am, how long did it take you to report this to somebody?
Within minutes.
Where was Mr. Buckner when you reported this?
He had walked out of the courtroom.
How long after he walked out of the courtroom did you report it?
Within probably 2 minutes, if even that,
To whom?
to the police officer passing by.
Which police officer? Is that officer here today?
Yes,
Okay, and that's who you reported it to?
yes.
That interaction, and if you look back on the right-hand side where the gentleman seated in the black shirt is, you're saying that's where you were sitting.
Yes,
When Mr. Buckner came down the aisle, you'll notice that the back row is basically a handicap accessible row or a non-handicap accessible row. You see that where it extends out?
yes.
How close was Mr. Buckner to you when he's making these comments?
He was past where the gentleman is sitting with the black sweatshirt, and he was in between that row and the woman sitting right behind him. And he leaned back and
he leaned back.
He was, yeah, turned his head back and spoke to me.
So because that's a little bit different than what you told me before, because you're saying that he was where the gentleman seated in the black
Right.
he was past him toward the door.
No, right, there's right where he's sitting, right there, at that spot, right there. It's like there's a spot, where you, not where you enter, but where would be if you're standing beside. So closer towards the opening of the back row.
So he's standing closest to the opening of the back row.
Right, but he's beside where the gentleman is with the black sweatshirt. And that's right.
But he's over on that side of the courtroom?
Yes,
So ma'am, are you telling me he's no longer in the middle aisle?
no, he crossed from the middle aisle to stand closer towards the right-hand side. He's no longer in the middle. He's standing like as if you're having a one-on-one private conversation with somebody.
How loud were these comments you say he was making?
They were not the other people who were walking out of the courtroom, I could hear them, but it's not like he was screaming them. They were normal voices.
When you testified in the previous matter, was there a victim's advocate assigned to you?
Yes, there was a victim's advocate.
Okay, so after you testified, did you talk to that victim's advocate?
No. They asked me to just go sit into the courtroom.
I want to go back, ma'am. At the time that you say Mr. Buckner got up, what's on the screens in the courtroom?
The screen was still on to where you could see where the judge was sitting. And then she called for a conference. And then the screen went blank. And then the screen went back up to where you could see where the judge was sitting. And then she called for a recess.
And then what happened to the screen when she called for a recess?
And then the screen went blank and said, you know, right, it didn't show any pictures, didn't show any people anymore.
Prior to the judge taking recess, was it Mr. Buckner's other case that was being heard, the case that you were there for?
That case had been heard, and then honestly, I know that case was heard, there was a witness, but I think he was sitting out in the galley, and I think that they had started to call for another case. Because I don't think that.
Had your case that you were there on, had it concluded at that point?
Yes, because he was sitting out in the galley.
Okay. So then my question is that case had concluded?
Yes.
The judge had made her ruling?
No, she had asked for some more information, and they had set it aside for a minute and was going to call it back up.
And so had they called another case?
Yes.
Was Mr. Buckner's attorney on that case?
No, he was sitting on the left side, where the gentleman is. He's behind the lawyer right now where the glasses is.
So he had moved back to the chair.
Yes.
But during Mr. Buckner's case, he was at the table with Mr. Buckner.
Yes.
From that period in time, that case ending until the judge took a recess, approximately how much time was there? Mr. Buckner, you said was in that first row, right?
Yes.
How far into that first row was he?
Like right on the end.
So he's right on the end, seated where I guess the young lady in the pink would be.
Yes, hi. I'm sorry.
Sorry to use people as props, but that's where he was sitting?
Yes,
Okay, so he's sitting right behind his attorney.
yes,
Okay. And then at some point he gets up
yes.
and walks back. Were you the only witness that had testified in that previous case?
No, it was me and one police officer,
Okay.
but I was the only.
Where was the police officer that testified?
He was sitting over, on the right-hand side where the gentleman is with the glasses.
Did he testify before or after you?
After me,
He testified after you.
yes.
Was there another witness then?
They stopped because the judge asked for information. So they were pausing it to see if they could collect the information that was needed to proceed with the case.
So just so I'm clear, you were the first witness to testify, right?
Yes,
The next witness was a police officer.
yes,
And all during that time, Mr. Buckner is at the table where approximately where he is right now.
yes,
Then at some point, there's a break. Mr. Buckner leaves the table
yes.
and is seated in basically the first seat in the first row behind defense counsel.
Yes,
Then another case is called,
yes.
right? And was it the attorneys? Was it the attorneys on that next case? Was that who the judge was talking to?
Yes. I don't know if it was it was someone from the state and then someone representing that person. So yes, that's who the judge was talking to.
They were the attorneys on the next case.
Yes,
Okay, and the judge spoke with them.
yes.
As the judge is speaking with them, what do you hear in the courtroom?
The noise coming from the speaker and
What noise?
the, whatever that noise is. I don't know how to describe it,
Okay,
but just so we can't hear what's being said up here at the bottom.
okay, so you hear that.
Yes,
At the point that you hear that, where is Mr. Buckner?
still seated.
Okay. The judge then leaves that session, gets up to walk out.
Right, but the screens turned back. When they went back towards their tables, the screens went back to where you could see the judge. And then they called recess.
All right. At the point that they call recess, where is Mr. Buckner?
That's when he stands up, goes towards the middle of it, and then there's two people. He goes, and then that's when he stops. There's two people getting out like in the next row.
How many people were behind Mr. Buckner in the gala?
Honestly, I don't know. I mean,
How many people was there a person sitting behind you?
I don't think so.
Was there a person next to you?
No.
Was there a person in front of you? Which would have been in the second aisle?
I don't. If there was, I think.
Didn't ask that. Do you know whether or not, okay, do you know whether there was a person 2 aisles up?
Yes. that
Who
the
was,
police officer.
and how far over was the police officer? You're saying where the gentleman that just sat down in the blue tie would be? Mr. Warren
No,
Green, that's your.
further over. He's probably where the other officer is, if not closer towards.
So he's further over toward the wall.
Yes,
Is there anybody else in that row that you recall?
No,
Is there any, so where you are, you're saying there's nobody in your row?
not that I remember, but not that I remember.
Behind you, you're indicating that there's nobody behind you in that row.
Not that I remember.
In front of you, the row would be directly in front of you. There's nobody in that row that you recall.
Not in front of me, there was someone down.
There was what?
There was someone down closer towards like where the gentleman is with the blue tie. There was two people right there.
There were two people right there?
Yeah. They weren't towards the edge, they were like in the middle down.
When Mr. Buckner allegedly makes those comments, do they turn around?
I was not paying attention. I just put my head down and just let it happen.
Council, I know, council approach briefly. This is too much. There was a.
So while he's muted, I personally don't know if she is just a bad witness or if she's horrible at recalling details or if she's lying but this whole thing is just, for me, is a mess. Let me know your thoughts. Yeah, it continues to amaze me the more court I watch, the inability of people to answer simple questions. They're given a yes or no, and they get into this long diatribe about their family history. Stuff like that. It's crazy. She's the ambient witness, puts you to sleep, and maybe, maybe Kazman. Yeah. I don't know if it's just modern society and this need for people to be seen and heard and all of that, but like nobody seems to have the ability anymore, again, to just answer simple questions. They just drone on and on and on. It's almost a look at me kind of performance. And they love to insert their thoughts, that's for sure, and start speculating on what the person that they saw was thinking deep inside their minds and all sorts of stuff. I don't know. But let's see where this ends here, and then we'll probably call it a day after that. By the way, if you haven't already, please do smash the like button for me if you've enjoyed the video today, or the live stream rather. If you're not subscribed to the channel and I've earned that subscription today, please consider doing so. Also in the pinned comment in the chat, there's 2 links. One is for our newsletter. Please do sign up for that. We're going to be starting that up in a few days. And Also a link to channel membership if you feel I've earned that and you're not a member. We'd love to have you. It's $2.99 a month, not a lot of money. That money goes right back into the channel, but you get some great extras, and we're going to, in the very near future, play around with a members-only pre-show and try that out for a while and see how that goes. So that'll be fun too. Michael, listening and understanding our dying art. Yeah. There are a lot of reasons why, a couple of decades ago now, I left the corporate world and started working for myself, and listening and understanding is one of them. It's very hard to lead people, especially in a corporate structure with HR constantly looking over your shoulder. It's very hard to lead them when they don't have ears, and what does sink in isn't comprehended, it seems. I don't know. Get on with it, Judge. The one thing I will miss about Judge Fleischer's court is that in the few times when, he would have sidebars, because you didn't see it that often because you rarely had trials and hearings and stuff, but you would get to hear what they were talking about during the sidebar.
All right, let's get
back to
it. So what I'm going to do in this case is, and I talked with counsel, I'm going to take a brief break, get some information, get it to counsel, and then continue the hearing after that.
May this witness be excused, or is the court obviously appropriate if the court wants to inquire based on reviewing the video?
Yeah, I don't want this witness excused at this point, because I may have questions, and the video also may give rise to questions from Mr. Johnson. All right. So we'll pause in this case. You may step down, man. And I'll call you back up. And court's going to take a brief recess. And I know people want to talk to me, but court's going to take but court will take a brief recess.
All right.
Okay, so I told you when we started this video that I went about 30 minutes into the Wayback Machine to pick this up at the beginning, and I'm looking at Judge's live feed right now, and they are still in recess, so his brief recess is not that brief. But we are into overtime already, so I'm going to call it here for the day. I want to see this. Yeah, so what I'm going to do is I'm going to keep my recorder running. And at the very least, what we'll do is do a follow-up during tomorrow's live show. If it's video worthy in and of itself, I can look at posting a separate video, but at the very least, we can discuss what happened tomorrow. But I'm going to leave the recorder running because Judge Simpson has been pulling his lives shortly after they're done. So if you don't capture it right away, you don't get it. So that's what I'm going to do there. But again, please do consider subscribing to the channel, becoming a channel member, hit the like button on the way out if you haven't already. All those good things help us out so much, and I very much appreciate all of you. I hope you had fun today, got to visit one or two new places, got to see some stuff. We'll do it again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Please do join us then. And in the meantime, go have yourself a good Tuesday. Take care and God bless.